Everybody have an item to convey?
Yeah, we got those. Okay. Put that, okay, these,
Everybody have an item to convey?
yes,
Everyone has a contingency to them?
yes.
Everyone has a contract to say?
I hope so. Yes.
Okay. We're gonna go over, these are the main ones we're gonna go over. Okay, these are the newest. In case you didn't know. Now, if there's something in here that you don't understand, my suggestion is always to seek competent legal advice.
Yeah, that's why we come here, buddy, okay?
You are.
That is your competent legal advice person right here, okay? Go someplace else, all right? It's gonna, you're gonna tick me off.
I am not an attorney. I do not play one on TV.
But you did stay at a Holiday Inn. That's what they say.
No, I haven't stayed at a Holiday Inn for a long time. All right, so. These are the most up-to-date forms that I am aware of for West Virginia, especially with the EPBR. So, for those of you that don't know, West Virginia made some changes, or Eastern Panhandle made changes to the forms to make it better for everybody. They did away with the jurisdictional addendum. So you no longer have a jurisdictional addendum to contend with. It's all part of the contract. Now legislatively, West Virginia hasn't changed a whole lot. They don't feel that there's a need to change legislation in West Virginia. The one piece of legislation that they did change for those of you licensed in West Virginia, if you have an LLC as of October 1st, you will be able to be paid, that LLC will be able to be paid directly from the broker.
Yay.
Yeah, that might only be temporary
Why?
because it was only put in place temporarily until they try to get them to change the code in West Virginia. Because they don't think the code needs to be changed or updated.
So do we still have the option to get it to direct deposit through here like we have been? Or-
Yeah, it'll still be direct deposit, but if you have an LLC set up, it'll just go straight into your LLC instead of
Okay.
to your personal account, then you take it and transfer it to your personal account. So West Virginia says that they don't need to make changes to the broker's code. And that's part of the broker's code, not paying an LLC, but they did temporarily suspend that, and they're looking at it. So you may want to reach out to your local elected officials in West Virginia, if you're a resident of West Virginia. Because they're the ones that are gonna be able to change the code and bring it up to date. So, contract to sale.
What are the negatives of that? I mean, why hasn't it already been, I mean, like, what holds it back from doing that anyway? I
The
mean,
legislature doesn't want to make changes to the code.
lazy. Okay, got it. All right, I'm ready. All right, I'm sorry. I'm just like, people are just amazing.
I mean, they just don't want to make changes to the code. They think it's sufficient. They don't think it needs to be. Okay. So contract to sale, you'll see there's 12 pages. On the bottom of it, it says 7/20/22.
Mhm.
Okay. Anybody has any questions as we're going through this? Let me know. I get it. It's pretty self-explanatory as we go through this. The sales contract is made on contract date. That's the contract date. That's not the date of ratification. Okay. And it's between, and you're gonna put the purchaser and then you're gonna put the seller. And the seller is never owner of record. The seller is always someone or some entity. And then who it's listed with, and then who the selling company is. In this instance, because we're working with a contract, you would put in there Keller Williams Premier Realty is the selling company. Now, the biggest thing you'll notice is right off the bat, it starts with, they represent the purchaser, the seller, or it's dual agent. With disclosed dual agency for both parties. So they start right off with that. Listing company and selling company are collectively referred to as the broker. If the brokerage firm is acting as dual representative of both seller and purchaser, then the appropriate disclosure form is attached. Now, what they call that form in West Virginia is the, oh, help me, Dorothy.
The
Dual
dual
agency.
agency explain.
Dual agency, the
Explanation,
explanation of dual agency is what it's called.
explanation.
So, now, in the past, what I have seen people do is they'll fill out the explanation of dual agency and leave it unsigned until a later time. Don't do that. If we get an audit and they pull it up on a listing and it's signed and it's not dual agency, we're gonna get hit. Or smack our fingers.
So we should have our listing, it's signed at listing. That they agree to the dual agency.
Correct.
Okay,
And it's just one existing client.
and
One
one,
existing
And,
client.
and everyone's signing it, and then
Yeah.
that one goes in and that's fine.
Correct.
What you're saying is people are not putting anything.
Correct. They're leaving it blank.
Oh, well, you should, nobody should sign it.
but the thing is, it's confusing on that, there's a place in the contract. To say if they agree to do it.
Yeah, that's on page.
Yeah, that's on page 1.
Well, no, there's another spot too, I think, right?
No.
Oh.
That would have been jurisdictional addendum, it's gone.
Oh, okay,
Yeah.
okay, that's right.
It's just on page 1.
And
Okay,
I
And
think
it's
that's
right
where
there,
the
it's in the first
confusion
par-
might be, because
Yeah.
they're agreeing to it in the.
in the contract.
It's in the first page.
Right.
And on your notice of agency, if you're doing the listing, you don't have a buyer yet, you're still doing it as the representing the seller.
Mhm.
So that's all. And then the real property, you're gonna break it down and try to put as much information as you can in these blanks. Because that's what we're supposed to do, is fill in as many blanks as we possibly can. So I look for that. I don't send it back if it's not all there, because sometimes it's not all available. And then it breaks it down to the payment. Down payment. Now, I've seen some come across recently where they'll use 10% down, financing 80%, or financing 90%, and the sales price is 100%. That's not how it's supposed to be filled out.
So what's the sales price?
That almost sounds scary.
Yeah,
It is, but I've seen them come across that way. And I have been like, do I send this back
Yes.
or do I accept? What do I want to do? Okay, so I do see that because the price is listed in here. So I left it. Oh. I'm not gonna be that picky, but I would prefer to see, which is why they have dollar signs there and not percent symbols.
Yeah.
So just make sure it's filled out correctly. And then whether or not they're gonna be obtaining a first deed of trust or assuming, and whether it's a fixed or adjustable rate interest. And then the type of loan. And then if it's not contingent on financing, it's all right there, page 1. Page 2. If it's a second deed of trust, you may see this if it's an owner financing situation. You're not really gonna see it any other time, I don't think. Then if they're gonna obtain a second deed of trust and whether it's obtainable, assumable, and if it's fixed or adjustable. And then under an assumption, if it's an assumption, now you may find somebody's willing to do an assumption to get the property sold.
I'm looking at one right now, I'm showing it today. Or VA, assuming that their VA a 2.78.
Oh, yeah.
I'm like,
Yes.
oh my God, that'd be.
how much do they want down? Did they say?
They didn't say.
Okay,
So,
wow, that's good.
I know.
That's where they might run into some issues a
Yeah.
little bit later, because they're gonna want a considerable amount then.
Oh, really?
Oh, yeah. If they're assuming it, they want, yeah,
Yeah, they're just assuming what they owe.
Yep.
So they need some money down to pay for what they actually are asking.
yeah. So keep that in mind.
Okay.
And then if it is an assumption, there it's marked down that if it's an assumption. And that they will or will not obtain a release for the seller's liability. That's important. If they will not obtain seller's liability, meaning seller would still be liable for that mortgage if they foreclose on it. So just watch that. There is a selection required below on time is of the essence, and they broke it down a little bit better for us. So time is of the essence to all terms of this contract. And what they're saying is time is of the essence means that the dates and time frames agreed to by the parties must be met. Failure to meet stated dates or time frame will result in a waiver of contractual rights or will be default under the terms of the contract. Reason they did that is because in West Virginia, if it was marked time is not of the essence, and you still had time frames in the contract, you had 15 days to do the contract, so do inspection, okay? If it was marked time is not of the essence, we can go to court and the judge would find that, well, time wasn't of the essence, so they didn't have to complete those inspections in 15 days. They could have done it whenever.
They're putting time on it.
Yeah. So, and that's what happened. So that's why they changed it. So always make sure that you mark time is of the essence if you want the time frames to mean anything. Otherwise, they
All
don't
time
mean
frames,
all,
not just the, when the contract is voided.
all time frames. Otherwise, the time frames don't mean anything. And the only thing that the time frame means is it's a reasonable amount of time. Well, what's a reasonable amount of time?
That to me doesn't make sense.
That's what it is.
No.
And that's what it said. So the deposit, the earnest money deposit in the amount of is either in hand or will be received within 3 days of ratification and shall be placed in a trust fund, either the listing broker, selling broker, or an attorney.
Okay. It's not a ratified contract if you don't get that money.
That's correct.
Not a valid contract,
It is not.
even if it takes them 4 weeks.
Now, because that was the terms of the contract. If they don't provide you with that deposit, when they say, then they're in violation of the contract. You're still entitled to that deposit. They didn't do what they were supposed to do. And then we all go to court.
And that's not an easy thing.
Now, one thing that I've seen a lot of people do here recently is, and it's happened on one of the West Virginia contracts already too, is they'll mark that the selling broker is holding the deposit, but then they'll say it's earnest. Just so everybody's aware, earnest does not hold the deposit. Earnest is the app that we use to electronically collect the person's deposit to put into our account. So nowhere on this should anybody be scratching anything out and writing earnest. Okay?
Unless you change your name.
Oh, did you know that NAR is accepting soon?
Yeah.
Isn't that great?
Really?
Yeah,
Yeah.
it's a big thing.
Oh, yeah.
They're trying to get.
They're even trying, they're trying to push it. And the big thing is, it's a security issue, really. Because when we make copies of checks and send them back and forth, and people intercede those emails, they get the routing number and the account number right off the check, and they can get hacked into your account.
So you go into NAR, kind of like you do earnest?
Yeah, no, NAR is making it a very acceptable way to get EMDs. to
Yeah.
answer. They recognize them and they're,
Now, if you still use .loop, you can go to Earnest in .loop as well.
it's a commander now too.
Yeah.
So it's becoming very.
It's becoming more and more friendly.
Which I'm glad, because that's a Keller Williams agent that created Earnest.
Yeah.
Yeah.
Yeah,
Okay, so then the deposit will be, and when you're getting an earnest money deposit, the purchaser needs to understand that that deposit is for good faith and that they could lose that deposit if they're in default of the contract. It will be credited on their sales price when they close. And the only way for it to be released is if all parties agree on its disposition. Otherwise, the court of competent jurisdiction would determine who gets it. Transfer tax shall be paid by the seller. Any HOA costs, including but not limited to the transfer fees, shall be paid by the seller. All normal annual HOA fees shall be prorated. Down payment, balance of the down payment will be paid on or before the settlement date by a certified or cashier's check. What is that? Delivery. Delivery or delivered methods may include hand carried, sent by professional courier service by United States mail, facsimile, or by email transmission. So it's in the contract. You don't need an additional addendum that says you can accept an electronic copy as delivered. Notices, they mean unilateral communication from one party to another. All notices required under this contract will be in writing and will be the day following delivery, and the time period will end at 9 p.m. on the day specified. Written acknowledgement of receipt of the notice is a courtesy, but it's not required. What does that mean?
I never received the document. It would be nice if they did.
Correct. Delivery is deemed to have occurred, one, by hand, or by professional courier service, or by United States mail, return receipt requested, or email and or fax. Acknowledged in writing by the recipient if any other method is used. Deliveries will be sent to the seller, wherever they're gonna have it sent to. Most times we put the listing agent, the purchaser, most times we put the buyer in the email. Copies of any addendum, amendment, and notices required by the contract will also be provided to the brokers or brokers representative at the following email address. Same thing, listing company and selling company. Because most agents, and you'll see, now I have seen some agents put the buyer's address or the seller's address or their email addresses respectively instead of the listing of the buyer agent. But there's some agents that don't want anybody to know that information, so they don't put it on there. They'll put their email. That's what I do. Any delivery to the broker or broker's representative, either principal shall or shall not constitute delivery. Be very careful in marking it. It should always be marked shall not constitute delivery. Why should it be marked shall not constitute delivery?
Because we don't know if that agent's getting it to their client
Correct,
in a timely manner.
correct.
Because you don't know, like, if you say delivering it to the broker or the agent shall constitute delivery, that means you met your deadline, but you don't know if that agent's getting it to their client. If it was not.
No party to this contract will refuse delivery in order to delay or extend any deadline. That has happened.
Apparently, because it's in here,
It has happened. I've seen it happen since I've been broke.
really.
Oh, yeah. Yeah, because they put in there that it shall not constitute delivery. And the person was out of the country for 2 weeks, so I couldn't deliver it to them. Okay,
The timelines from this.
Yeah. Settlement. Seller and purchaser will make full settlement in accordance with the terms of the contract on or with mutual consent before. Settlement date, where do you get your settlement date from?
The lender.
Correct. The lender will usually tell you when you can go to closing. Except as otherwise provided in this contract, the purchaser selects. Buyer is going to select the title company, whoever he wants to use, that's who you're going to put here. To conduct the settlement. Either party may retain their own legal counsel. And the purchaser agrees to contact their settlement agent within 10 days after ratification. Because they have to get started on title work. I remember correctly, I think somewhere in here within 7 days, they have to get started on title work, so they're giving you 10 days to get in touch with the property maintenance and condition. Property must be free and clear of all trash and debris. Room clean and in substantially the same physical condition to be determined as of. Contract date, date of the home inspection, or other. What's the correct answer?
I put the day of the home inspection.
Date of settlement. Because they could clean it and go make a mess.
Well, the date of settlement could be that they've destroyed the property. You've accepted the condition of the property, the date of settlement.
I think either contract date or home inspection date.
Either the home inspection or the contract date. I usually use the contract date. And the reason I use the contract date is because it should be in the same condition, same appliances that were advertised, and nothing swapped out. Purchaser acknowledges, subject to the seller's acceptance, that the contract may be contingent upon a home inspection and whether or not it is. And it specifies this contract is either contingent upon inspection, and you must attach the addendum, or the purchaser accepts the property and sold in as is conditioned without any inspections or contingencies regarding the condition of the property as of the date specified above, which is contract date. Access to the property. The seller will provide the broker, purchaser, inspectors representing the purchaser and representatives of lending institutions for appraisal purposes, reasonable access to the property to comply with this contract. In addition, the purchaser and purchaser's representatives will have the right to make a full inspection within 5 days prior to settlement and or occupancy, unless otherwise agreed to by the purchaser and seller. So what does that basically say? What does that say?
You're not coming back in until it's time for final inspection.
If your timeframes have already
Been done.
been done, the purchaser does not have the right to go back in and measure rooms or measure for curtains or to look at other issues that might be coming up. You're done with your time frame period. We've allowed access to that. Now you have to wait until 5 days before closing to go through the property. Utilities, water, sewage, heating, central air conditioning, you're gonna check all that apply. Make sure that your seller tells you exactly what it is that's there and make sure that it's correct. Personal property and fixtures, see the items to convey addendum. In bold. Because it states that the property includes the following personal property and fixtures. And this was changed, just so everybody's aware. If existing, exterior trees and shrubs, built-in heating and central air conditioning equipment, plumbing and lighting fixtures, sump pump, attic, exhaust fans, storm windows, storm doors, screens, and installed wall-to-wall carpeting. All surface or wall-mounted electronic components and devices do not convey, unless otherwise agreed to in writing. All wall brackets and or mounts do convey. Any component bracket or mount removal requiring wall repair shall be corrected by the seller, including paint.
We didn't have including paint before.
It didn't have it
It just
before.
had to, you just had to cover up the
Right,
hole.
so they're big
So
white.
what they're saying now in the contract is, unless it's agreed to in the items to convey, the wall mounts do convey with the property, so they should not be taking them off. The electronic components attached to those wall mounts do not convey.
When I tell my client, they either have to leave that big bracket. Well, I wanted to take it with me. I said, well, when you take it down, you gotta fill in those holes and paint it. And they're looking at me with the deer in the headlight look, and they're like, I'll just get a new one.
Before long, this will have to be updated to say including matching paint, because it doesn't say it has to be the same color.
Yeah.
It's what's on the wall.
That's true.
They paint it white and it's.
That's why I said I'm just gonna have a big black thing like that. Oh, it's painted.
I made you a chalkboard.
Well,
It has to match.
somebody brought that up when we were going over these changes with folks at EPBR and the Real Estate Commission. There were two commissioners present. And the comment was made, well, if the wall is red, you're taking the bracket off and you fill a hole, you gotta paint it red.
There's all shades of red. I'll make sure to pick a really nice one.
Well, I've already had this happen to me and, I got experience with this now. I went to Sherwin-Williams. I had to cut out a little piece of the wall, just a little square piece, and I took it and they matched the sheen and the color.
Oh, wow.
Exactly.
So they gave you a little sample?
No, I had to cut it out of the wall.
No, but I mean, when you bought the paint, did you have a little container? So you needed one section.
There was a lot of, it's what. It was, my buyers, but we had asked the seller if, they would have all the little nail holes, which actually took me later. Man, you should never do that. But I had done that, and then when we did the walkthrough and they saw all the patches, they were so upset and disappointed. Felt like it was on me, so then I took it upon myself to repair it and fix it right. So I just took a little patch out of the
Was it
wall
in West
myself.
Virginia?
It wasn't, it was in Maryland.
Well, in West
Every day, that's
Virginia,
all I'm saying, go to Sherwin.
in West Virginia now, it's the seller's responsibility to do that.
Well, you can tell your seller, go to, Sherwin.
And then match it
Yeah,
for you.
if you cut out a little square of the paint, yeah, they will, they're good.
And then lease items, if there's any lease items, systems or service contracts, including but not limited to. Fuel tanks, that's gonna be the biggest one. Propane tanks are the biggest lease item. Water treatment systems, lawn contractors, security systems, satellite systems, and as we know, solar panels. They do not convey, absent an express written agreement by the purchaser and seller. The following is a list of the leased items within the property. Make sure they're all listed. Whether or not there's gonna be a home warranty, we do offer home warranties to buyers. That we can either get the seller to pay for it or the buyer will pay for it. You do have to put down the warranty provider now. And that the cost cannot exceed X amount. Financing, if this contract's contingent on financing, the purchaser has to make written application within 7 days. For contract acceptance. And the purchaser grants permission for the listing company and the lender to disclose to the listing company and the seller general information available about the progress of the loan, the application, the loan process. If the purchaser fails to settle except due to any default by the seller, then the provisions of the default paragraph shall apply. Seller agrees to comply with reasonable lender requirements, except as otherwise provided in the lender required repairs paragraph of the applicable financing contingency addendum. Okay. Financing, mortgage rates and associated charges vary among financial institutions and fluctuate according to market conditions. The purchaser has the opportunity to select a lender and the right to negotiate terms. Well, I heard of staff. Is there somebody in? No, okay.
Lenny, I have a question under financing.
Yeah,
If the seller signs the financial addendum, I believe in there, it does say the seller will repair, right? But the contract, if it's being sold as is, it kind of is a conflict.
that's why it says under lender required repairs, paragraph of the applicable financing. So whatever's in the financing contingency, so if the lender required repair. And I believe in the financing contingency in West Virginia, it states that the seller will make the required lender required repair. Now, we all know that doesn't necessarily mean that the seller's gonna do it.
Right,
Seller
that's-
might refuse,
I have a.
but at that point, if the seller refuses to make those repairs, then you get out of the contract. And he has to give the deposit back, can't keep it. Okay. Say, no, financial to determine this contract, the financing may require a substantial lump sum balloon payments on due dates, and the purchaser has not relied upon any representations regarding the future availability of mortgage money or interest rates for the refinancing of any such lump sum payment. Now, they changed this paragraph a little while ago, the next one, which is number 16, alternate financing. In West Virginia, the purchaser may substitute alternative financing and or an alternate lender for specified financing provider. The purchaser is qualified for alternative financing. There's no additional expense to the seller, and the settlement date is not delayed. If the purchaser fails to settle except due to any default by the seller, then the provisions of the default paragraph shall apply. This is in bold because if you change lenders in West Virginia and that new lender cannot meet the closing date, and that new lender needs an extension of time or anything that's going to change it, or it's going to cost the seller some more money, the seller can declare the contract null and void and keep the deposit. That's what that paragraph means. Purchaser's representation. I'm glad to see that they fixed this on the contract. On the old contract, it said the purchaser, and it looked like a D. Will or, and then it looked like a D, will not occupy the property. Because a lot of people don't check that when it looks like a D.
You always had to go fix that when you get sick.
Yep.
Pain.
So they're either gonna occupy the property or not. The seller does have a right to know whether or not they're occupying the property. It also depends on what type of loan. If the selling company is or is not authorized to disclose to the listing company any lender financing information, I usually put in here that they are. You can put your, they're not, but then they can refuse your offer if they choose to, because they want lender information.
Well, okay. Cause I remember you telling me to put is not at one time.
Probably.
Okay. So my question is. This is not information about the client, this is information about the lender,
This is information about the loan.
from the lender's perspective.
Correct.
Saying, is this a liable person? Cause I've had,
Correct. Because the lender's not allowed to disclose information that is privy to just the purchaser. So if the guy filed bankruptcy 6 months before he wrote this offer, nobody knew that he found out. The lender can't necessarily disclose that to the listing agent or the buyer's agent, because that's got to do with his credit report. He can just say that we had to deny the loan. And that there was an adverse comment that created the loan demand. Okay,
Hey, in West Virginia, if they terminate for the home inspection, per what I read, they still have to send you a copy of why they're terminating.
they do.
Okay, well, I didn't receive that and bitch won't give it to me.
Okay. So I just need to know who.
Okay. Because now we're trying to correct what apparently scared them, and we don't know what, why, when, how, and I know the inspector, but for his law regulations and everything like that, he can't disclose it to me because we were not his client. So he's trying to walk that thin line, and he gave me a roundabout of what, but he
Of course,
can't,
it depends too on the, okay,
like, I understand
Hold that-
you don't have to disclose,
hold,
I
hold
get
that
that.
thought, hold that thought. No, in West Virginia, you do have to disclose anything that's gonna affect the value or the condition of the property.
If it's a latent defect, it has to be.
It has to be
Well, it's not,
disclosed.
it's not a late,
And,
but
and they
I,
have up until 5 days before closing to disclose that.
well, she never sent anything, like, so they stopped the inspection and they would not allow him to finish it. Now, and I talked to him, because it's the inspector I use for my property, and I'm like, well, write up a partial report, and then at least we can get a partial report to show why they terminated, so that we can work on correcting it. And,
Can't do that. I mean, the buyer has to give that to you.
The buyer has-
well, no, the agent, if they're terminating, the agent has to give it to us.
Yeah.
I know that, but I mean, but the buyer paid for it.
Yes,
The buyer paid for it. It belongs to the buyer. It
but
doesn't
if
belong
they're
to the agent.
terminating for the
If they're
contract,
terminating
they
for the
have to
contract, you
provide-
have to give the. Depending on which, depending, and we'll get into that, because depending on what was checked,
Right, okay. Like the right to terminate without, okay, got it. 'Cause there's
like,
two
if they're
different ways of-
terminating, they have to provide it. And
well, it
One
that
of them.
depends, one of them it is, one of them- and it depends on whether it's the old contingency or
Or
the
the
new
new one.
contingency.
yeah, so they have the right to terminate based off the home inspection, they have to provide it. They won't.
Not
So,
necessarily, hold that thought,
So.
hold that thought,
Yeah, we're gonna-
not
okay.
necessarily, hold that thought. All right.
That goes under the old.
Damage or loss, the risk of damages or loss to the property by fire, act of God, or other casualty remains with the seller until the execution and delivery of the deed of conveyance to the purchaser at settlement.
I think
Title.
we need to change the act of God to the act of, global warming. Just.
Or
I'm
the
not on
act of
the
Holly.
Title. So this is the biggest difference between the standard contract of sale for residential property and the land contract of sale.
Oh.
So the land contract of sale. Anyway,
It's small.
all it says is. It's only one paragraph. So under the land. So the title report and survey, if required, will be ordered promptly, and if not available on the settlement date, then the settlement may be delayed for up to 10 business days. To obtain the title report and survey, after which the contract at the option of the seller may be terminated, and the deposit will be refunded in full to the purchaser. So if they come back with a title defect, there's an automatic 10-day extension to get it remedied before closing, and then you can still close if they have it remedied. If it's not remedied, then you can declare the contract null and void, and the deposit will be returned to the purchaser. The simple title to the property and everything that conveys with it will be sold free of liens, except for any loans assumed by the purchaser. Title is to be good, marketable, and insurable by a licensed title insurance company with no additional risk premium. Title may be subject to commonly acceptable easements, covenants, conditions, restrictions of record. Otherwise, the purchaser may declare this contract void unless the defects are of such character that may be remedied within 30 days beyond settlement date. Then all parties would have to agree to extend. In case action is required to perfect the title, such action must be taken promptly by the seller at the seller's expense. Brokers hereby expressly released from any and all liability for damages by reason of any defect in the title. The seller will convey the property by general warranty deed. That's just general in West Virginia. Seller will sign such affidavits, lien waivers, tax certifications, and other documents as may be required by the lender, title insurance company, settlement agent, or government authority, and authorizes the settlement agent to obtain the payoff or assumption information from any existing lenders. The manner of taking title may have significant legal and tax consequences, and the purchaser is advised to seek the appropriate professional advice concerning the manner of taking title. Unless otherwise agreed to in writing, the seller will pay any special assessments and will comply with all orders of notices of violation of any county or local authority, condominium, unit owners association, homeowners or property owners association, or actions in any court on account thereof against or affecting the property of the settlement. That covers a lot of different scenarios that come up. Land contract doesn't cover any of it. Possession date, unless otherwise granted, agreed to in writing between the seller and purchaser, seller will give possession of the property at settlement, including delivery of the keys, if any. If the seller fails to do so and occupies the property beyond settlement, the seller will be a tenant at sufferance of the purchaser and hereby expressly waives all notice to quit as provided by law. Purchaser will have the right to proceed by any legal means available to obtain possession of the property, and the seller will pay any damages and costs incurred by the purchaser, including reasonable attorney's fees. Fees for the preparation of the deed, that portion of the settlement agent's fee billed to the seller, costs of releasing existing encumbrances, seller's legal fees, and any other proper charges assessed to the seller will be paid by the seller. Fees for the title exam, except as otherwise provided. Survey, recording, including those for any purchase money trust in that portion of the settlement agent's fee billed to the purchaser. Purchaser's legal fees and any other proper charges assessed to the purchaser will be paid by the purchaser. Fee to be charged will be reasonable and customary for the jurisdiction in which the property is located, and recording, transfer, and grantor's taxes are covered in the appropriate jurisdictional addendum. They forgot to remove that section of it because there's no longer a jurisdictional addendum. Broker's fee. Seller irrevocably instructs the settlement agent to pay the broker compensation at settlement as set forth in the listing agreement and to disperse the compensation offered by the listing company to the selling company in writing as of the contract date and the remaining amount of the broker's compensation to the listing company. Adjustments, we all know what they are: the rents, taxes, water, sewer charges, they're all going to be prorated along with HOAs. Or condo fees. I don't think there's too many condos in West Virginia, ever. Good thing. And they will be prorated up to the day of settlement and then from the day of settlement. Yeah. Any heating or cooking fuels remaining in supply tank become the property of the purchaser at that time. Unless it's a leased tank. Taxes, general and special, are to be adjusted according to the certificate of taxes issued by the settlement, whether assessments have been levied or not, will be paid by seller or allowance made at settlement. If a loan is assumed, the interest will be adjusted to the settlement date and purchaser will reimburse the seller for existing escrow account amount. The attorney's fees, we all know that if anybody goes to seek competent legal advice, you're going to be responsible for your own attorney's fees until somebody's found at fault, and then you're going to be responsible for all the attorney's fees. No matter what. In the event of a dispute arising, resulting in the broker, as used in the paragraph to include any agent, licensee, or employee of the broker, being made a party to any litigation by the purchaser or by the seller, the parties agree that the party who brought the broker into litigation shall indemnify the broker for all of its reasonable legal expenses incurred, unless the litigation results in judgment against the broker. Don't get sued. Performance, delivery of the required funds and executed documents to the settlement agent will constitute sufficient tender of performance. Funds from this transaction settlement may be used to pay off any existing liens and encumbrances, including interest to other lien holders. If the purchaser fails to complete settlement for any reason other than default by the seller. This is also not in the land contract, which is very surprising. At the option of the seller, the deposit may be forfeited as liquidated damages, not as a penalty, in which event the purchaser will be relieved from further liability to the seller. If the seller does not elect to accept the deposit as liquidated damages, the deposit may not be the limit of purchaser's liability in the event of a default. If the deposit is forfeited, or if there is an award of damages by a court for a compromise agreement between seller and purchaser, the broker may accept and the seller agrees to pay the broker 1/2 of the deposit in lieu of the broker's fee, provided the broker's share of any forfeited deposit will not exceed the amount due under the listing agreement. If the seller fails to perform or comply with any of the terms and conditions of this contract, or fails to complete settlement for any reason other than default by the purchaser will have the right to pursue all legal or equitable remedies, including specific performance and or damages. If either the seller or purchaser refuses to execute a release of deposit, when requested to do so in writing and the court finds that such party should have executed the release, the party who so refused to execute the release will pay the expenses, including without limitation, the reasonable attorney's fees incurred by the other party in the litigation. The seller and purchaser agree that no escrow agent will have any liability to any party on account of disbursement of a deposit or on account of failure to disperse the deposit, except only in the event of the escrow agent's gross negligence or willful misconduct. That's not in the land contract. Parties further agree that the escrow agent will not be liable for the failure of any depository in which the deposit is placed. The seller and purchaser each will indemnify, defend, and save harmless the escrow agent from any loss or expense arising out of the holding, disbursement, or failure to disperse the deposit, except in the case of the escrow agent's gross negligence or willful misconduct. If either purchaser or seller is in default, then in addition to all other damages, the defaulting party will immediately pay the costs incurred for the title examination, appraisal, survey, and the broker's fee. So let's talk about this period, this big long section. So if the seller is in default, the purchaser can sue for specific performance and take the seller to court. We actually had somebody that took the attorney with them to closing to expressly let the other agent know, because the agent was practicing law and said that the seller wasn't going to sign, and she showed up on behalf of the seller because they didn't have a tax ID number because they were in the country illegally.
The seller was here illegally?
Correct. So we sent the attorney to the closing table. Needless to say, the following day, they made sure that the seller was present. Seller signed off on everything because we were going to sue for specific performance of the contract, which would have really created a lot of issues for them. And once the agent started telling the attorney, I love it, that they weren't going to sign it because they could end up getting in a lot of trouble, the attorney said, well, when I got my law degree, and I'm sure it was right around the same time you got yours. And she just kind of shut up from that point forward. Because she didn't have a law degree. And she went on to tell them that they were going to be in even more trouble. Because not only would they be coming to closing, INS would bring them to closing. Yeah. So in that situation, it worked out really good. But if the seller refuses to go to closing, the purchaser can sue them for specific performance. And in West Virginia, they take that pretty serious. There's been a couple cases where the purchaser has won. And it seems like every time the purchaser does sue for specific performance, they do win.
I just take myself to closing. I go call him and say, I'm here to find the bag. Let's get in the car. I'm gonna get you some coffee. We're going today.
Now, if the buyer goes into default, if the seller signs off on the release that he's taking the deposit and releases them from the contract of sale, then he's limited to those liquidated damages from the deposit. He doesn't have to sign the release. He can then sue the purchaser. You can do a unilateral notice of termination. In West Virginia, you can do it now. The thing that I find funny is there are no forms for unilateral notice of termination in West Virginia. But you can unilaterally terminate the contract and not agree on the disposition of the deposit. And what would happen is they would seek competent legal advice. What would happen is the seller would take the buyer to court and sue them. Once he's terminated the agreement, has another agreement on the property, if it's being sold for less than what they originally agreed upon, that buyer could be liable for that difference. So if it's $25,000 difference, that buyer could be responsible for $25,000 plus if they had a $5,000 deposit.
You're saying the first buyer didn't get it
Correct,
because he was the cause of them.
because he was in default and the seller chose not to release the deposit or accept the deposit. But if the seller accepts the deposit, and that's what these paragraphs are saying. If the seller accepts the deposit, then there are no further liquidated damages that can be done. Okay. Other disclosures, the purchaser and seller should carefully read this contract and be sure that the items accurately express their respective understanding as to their intentions and agreements. The broker can counsel on real estate matters, but if legal advice is desired by either party, what? Such party is advised to, what? Seek legal counsel in bold. Purchaser and seller are further advised to seek appropriate professionals' advice concerning the condition of the property or tax and insurance matters. We as agents are hired to fill in blanks and we cannot direct them in any way. They need to seek competent legal advice. They need to seek competent insurance advice. They need to seek competent tax advice. You got no parts in that. Property condition, various inspection services and home warranty insurance programs are available. Brokers not advising the parties as to certain other issues, including but not limited to water quality, including but not limited to lead and other contaminants, sewer or septic, soil condition, flood hazard areas, possible restrictions for the use of the property due to restrictive covenants, zoning, subdivision or environmental laws, easements or other documents, airport or aircraft noise, planned land use, roads or highways, and construction materials and or other hazardous materials, including but not limited to flame retardant, treated plywood, radon, urea, formaldehyde, foam insulation, mold, polybutylene pipes, synthetic stucco, underground storage tanks, defective Chinese drywall, asbestos, and lead paint. Information relating to these issues may be available from the appropriate government authorities. You should direct them to home inspectors, contractors, the EPA, etc. Because we make no representations on any of that. If they're looking for the covenants and restrictions, the buyer's agent and the buyer should seek the advice from the attorney that's handling the closing to gather those documents.
What I've been doing is going directly to the HOA,
You can do that.
and then I just send the link over to
Yeah.
On the buyer's agent.
Now, the seller is supposed to pay for those documents.
What if they're prospective buyers? Like I have that land contract in West Virginia and they want to know, about covenants restrictions. And I just gave them the president of the HOA's name and phone number and like, here, call here.
That's-
They tried to call the law office who handled the previous closing and they were not happy that. We're being
That's the responsibility.
Who was it?
It was the previous closing happened many years ago. Latrell handled
Okay.
it.
But there's still an attorney.
They're still the
They
attorney.
weren't happy.
Oh, wow.
So I just gave him the HOA president's name and number and said, you'll have to contact them, but there were a couple agents who were really pissed at me that I,
Yeah, we don't do that.
dig up that information.
And we're not the only ones. I know Marty Bartles doesn't let long and foster agents do it too. Because, and we've already had it happen in this office, where somebody handed over, HOA documents,
And there was missing pages.
and they were missing every other page of all the HOA documents. The guy bought the property.
Yeah.
He wanted to be able to hunt. And on one of the missing pages, you ain't allowed to hunt.
Maybe somebody.
So, yeah,
Well, but I mean.
legal requirements. All contracts for the sale of real property must be in writing to be enforceable. Now, what's funny about West Virginia is their contract can be on a napkin as long as both buyer and seller wrote it. It's binding.
I'm not gonna tell my people that.
No.
Right.
They'll be all over it.
Oh my gosh.
Yeah, what do we need you, what do we need you for? I got a napkin right here.
Got a little barbecue sauce on it, but other than that, it's good.
The broker. Purchaser and seller acknowledge that the broker is being retained solely as a real estate agent and not as an attorney, tax advisor, lender, appraiser, surveyor, structural engineer, molder, air quality expert, home inspector, or other professionals relating to life. The broker may, from time to time, engage in the general insurance, title insurance, mortgage loan, real estate settlement, home warranty, and other real estate related businesses and services. Therefore, in addition to the broker's fees specified herein, the broker may receive compensation related to other service provided in the course of the transaction pursuant to the terms of a separate agreement disclosure. The separate disclosure would be like for those of us that use Keller Mortgage. There is a disclosure, it's an affiliated business disclosure. We do have to provide that to them.
Do we have that in, DocuSign?
Yeah, and you can, and a lot of times the person will actually get that disclosure directly from Keller Mortgage as
Okay.
well, to sign part of their loan package.
Because I didn't do that.
Now, the only thing that now I know Katie used to send us the signed disclosure. I don't know that any of the other, have you ever gotten signed disclosure back from mortgage people?
I don't think I have.
Yeah, we need to make sure that we do request that for our files if we don't have them sign it ourselves.
That applies to Maryland as well.
That applies to all states. Doesn't matter what state. West Virginia withholding for sale of real property by a non-resident. It says that the person's a non-resident, they're gonna withhold sales tax. The person's gonna have to file a tax return in order to get any of that sales tax back. And I think, it doesn't tell you in here how much it is. I think it's like 14%.
Pretty steep.
Yeah, that they keep. And there used to be. Thought isn't there a non-resident addendum?
I thought it was on the,
I'm pretty sure there is.
Check.
Yeah, there's a non-resident addendum for EPBR.
it's on the, it's on.
I
a
think it's a
contract.
check
It's on a
point.
check point. When you
Yeah.
when you mark it and you say you're a resident or a
Yeah.
non-resident, and it might have been on the jurisdictional.
It was on the jurisdictional because now it's in here under the contract of D, West Virginia withholding for sale of real property by a non-resident in connection with the sale of a non-resident's property. West Virginia requires a settlement attorney to withhold funds from the net proceeds. A non-resident income tax return may be required in order to report the sale and determine the total tax due.
Where is that?
That would be page 8. of 12.
Right there, West Virginia.
Okay, but there should.
But you don't say whether they are or not, it just tells them if they are.
Just tells them if they are. I think there's a separate, if I remember correctly, there is a separate addendum for that.
So that's a
West
new
Virginia.
thing?
And I think that's where it says it's like 14%. It's pretty high.
Because,
And then the IRS interpreter withholding taxes for foreign sellers. They're gonna withhold taxes on a foreign person or a foreign entity at 15%. That's what that basically says. Property insurance, the buyer has to obtain property insurance, and because it's a requirement of the lender. If they're not getting a loan, that really won't matter, it's cash. But you should always recommend they get property insurance. But there's a lot of people that don't have loans on their properties and don't have property insurance. But they're not covered. If and I've got this question out there, because I feel like if the seller does not owe anything on the property, because the seller is responsible for the property from the date that the contract is accepted until it closes. If they do not have homeowners insurance on that property, that could be a big issue. I've asked if they should be telling purchasers whether or not there is homeowners insurance on the property. I've not gotten an answer back.
I would think it may not matter, because the purchasers are not gonna own it until the day of settlement, and they have to have insurance in place. So if something were to
but
happen before.
If the house burns down
Yeah.
the day before closing,
Right.
that's an act of God that you can't touch. That's just the way it works, then it becomes void.
and purchaser may still want to move forward with purchase for some reason.
A burned down house.
There's one for sale right now on the MLS out in. Neighbors, it's
Yeah.
manufactured home, you're selling for 60,000, the whole thing's all burned down on you.
Oh my God.
Go the other drive.
Yeah.
So on that non-resident thing, there is a listing in that,
That's what I thought.
but it doesn't tell them how much, it just refers them to go to the tax.
To the
department.
tax
Tells
department.
them where to go to tax.
Okay. The purchaser hereby expressly states and acknowledges that they have received a copy of the seller's voluntary property condition disclosure statement if provided. So why did it say if provided?
They don't,
Is there
it's voluntary.
exemptions?
Is it?
Yes, it says voluntary.
Yes.
States it on this title.
Is it?
Yes, it is.
West Virginia law said.
You have to disclose a latent defect no matter what, but you don't have to do a property disclosure.
You don't have to do the disclosure.
You have to do
Oh,
the
but you have to do
disclaimer.
page 5.
You have to do page 5, which is the
Disclaimer.
disclaimer. And you have up until 5 days before closing to
Really?
do that.
I have my.
Yeah, 'cause West Virginia law- West Virginia law, when it talks about the disclosure disclaimer, West Virginia law says that if it is a material or latent defect that is going to affect the condition or the value of the property, it must be disclosed within 5 days of closing.
I don't think that's fair.
No, I don't
Yeah.
either.
And there is, and West Virginia does not have a set standard or form to do that. But there are local boards that have documents that they encourage people to use. And that's that voluntary disclosure / not voluntary disclaimer, it says disclaimer. Avoid wire fraud, property taxes, as you know, property taxes in West Virginia. For those of you that don't know this, property taxes are always rear. Meaning that when your buyer gets the tax bill next year after moving in, in the former owner's name, that's his tax bill.
And if it was a rental, you're paying renter's insurance,
You are.
renter's tax until the full year is done.
Until the 4 years.
It is done, and that can affect your loan, unfortunately.
Yep. It sure does. And there's no way to know how much you're gonna have to pay until 1 year after. When,
They do estimates, but it's.
Yeah.
You just,
and then it tells us in here to avoid wire fraud, because wire fraud is a big thing now. And then all the purchaser due diligence from the, jurisdictional addendum is listed in here. And it puts all the liability on the purchaser. Here's what, 1, 2, 3, 4, 5, 6 categories of the purchaser doing the due diligence.
when I'm doing this in my presentation with my clients and I read this to them and I'm gonna start having them initial it. Because I had someone say, I don't think you're telling me that. And it bothered me, but now I'm gonna have them initial it as we do it. Because you know what, they need to read it.
So part of the purchaser's due diligence, is getting documents from the courthouse if they need to, finding out about the HOAs, finding out the things like that. That's all part of the purchaser's due diligence. Now, you as an agent, you may want to provide a type of service where you help them in contacting the courthouse and in contacting the attorney and in contacting the tax assessor. But I typically just say, oh, sure, here's the number for the tax assessor's office, you can give me a call. Here's the number for the HOA president, here's the number to the attorney's office that's handling it. You don't want to hand over the documents, you don't make any assumptions right away. Assignability says this contract cannot be assigned to any other person without express written agreement. If the contract becomes void and of no further force and effect without default by either party, both parties will immediately execute a release directing that deposit to be refunded in full to the purchaser according to the terms of the deposit. So when does the contract become void?
Timelines. Could be, right?
Well, if it's
If it's
beyond the
dependent
time,
on
if it's beyond the timelines and you don't declare the contract null and void at that point, then you still go on, you've waived your right to declare the contract null and void. If neither party shows up at closing, then what?
You're both at default.
You both basically declaring the contract null and void. My suggestion is to talk to an attorney to find out how contract would be void. If a person's mental capacity is questioned, it's void. I think in West Virginia, that's probably one of the few things that will void a contract. Same
One of
thing
the
with
thing is in West Virginia, they have to sign.
Yeah.
Either the power of attorney with witnesses and a notary, or they have to be at the table whether they're incapacitated or not. Unless they're dead, that other person cannot, so. It's nuts.
That's when it would become void, if that person can't be there.
Right.
So then everybody's just kind of like out, gets the deposit back. Other legal matters could take place, but then if the person's mentally incapacitated, they had no right trying to sell the property to begin with.
Right.
So it's a moot point. Privacy Act, seller and purchaser authorized their respective attorneys and settlement agent to furnish listing broker and selling broker copies of the final HUD and settlement statement and the alter. Additional fees, grantor's tax, transfer tax shall be paid by the seller. HOA costs, including but not limited to transfer fees, shall be paid by the seller. All normal annual HOA fees shall be prorated. Goes into arbitration, nothing in this contract shall preclude arbitration under the code of ethics and standards of practice. Definition, it goes into definitions, appraiser, days, what the days mean. Calendar days are always the day after, start, that's your day count where it starts, and it always ends at 9 p.m. unless agreed to different. In West Virginia. Miscellaneous contract may be signed in one or more counterparts. So if you have two contracts, the seller signed one contract, the buyer signed another contract, they didn't sign together, they are in counterpart. Just makes it a little bit harder to be enforceable. But they are in counterpart. That's what that means. The contract binding upon all parties in each of their respective heirs, executors, administrators, successors, and permitted assigns. The provisions not satisfied at settlement will survive delivery of deed and will not be merged therein. Contract, unless amended in writing, contains the final and entire agreement of the parties, and the parties will not be bound by any terms, conditions, oral statements, warranties, or representations not herein contained. The interpretation of this contract will be governed by the laws of the jurisdiction where the property is located, which is West Virginia. In West Virginia, you have magistrate court and district court. Magistrate court cannot determine anything with the contract of sale for real property. It has to go to circuit court. Expiration of the offer, the nice thing is they put a blank in here for you to put an expiration for the offer. What forms are included? You'll mark down which forms are included. There's a couple of them. And then if there's other forms that you want to have included in it, they gave you a bunch of space to write those other forms.
They fixed it too, because in DocuSign, it's used to check, like, I think it was the West Virginia note, no, I forget which one it was. You check one box and then try to check another one, it would uncheck the other one, then you have to drop the check mark on, that was like.
Or you have to remember when you go to have them signed, make your own little box.
Yeah, but they fixed it, now it doesn't do that anymore.
Yep.
Look at that, small court.
And then you're always gonna put the date of ratification. And then, of course, the information here on the bottom for the both agencies. So the contingencies addendum. Now, the contingencies addendum looks a lot different than it did before.
Yeah.
Is there anybody on in Zoom?
No.
One,
One, I
That's
think
probably me.
that's us.
Okay, so good. So everybody's got the contingencies addendum in front of them. I'm not gonna worry about digging and finding it. So you're gonna notice that with the contingencies addendum, this was done intentionally. I don't understand the intention behind it, but it was done intentionally. The reason I say that is the addendum's made on the date, so a sales contract dated the date that the sales contract was dated between the purchaser and the seller for the purchase and sale of the property. You're gonna put the address. Following provisions, if initialed by the parties, are incorporated into and made a part of the contract upon ratification. By selecting 1A or 1B below, the seller is relieved of any inspection remediation requirement. Okay? As is without any inspection. Property is being sold in its existing condition without any inspections or contingencies. Seller will make no repairs and will convey the property without any representation or warranties, either expressed or implied. B, as is with any inspections and right to terminate. Property is sold as is, condition as of the ratification date of residential sales contract, purchaser's expense may have the property inspected in the event the purchaser is dissatisfied with the result of any inspection the purchaser, upon written notice to the seller given within a number of days from the date of ratification date, shall have the unconditional right to terminate the contract. If the purchaser elects to terminate the contract shall become null and void, and the deposit shall be distributed in accordance with the deposit paragraph of the contract. If the purchaser fails to have inspections performed or fails to submit written notice of the termination within the time period specified, the purchaser shall have no right thereafter to terminate the contract, and the contract shall remain in full force and effect. Seller shall make the property accessible for such inspection. Neither purchaser nor any agent or contractor of the purchaser shall in any way excavate, penetrate, or otherwise damage any part of the property without prior written consent of the seller, nor shall any furnishings, boxes, or personal property belonging to the seller be moved or relocated unless absolutely necessary in connection with the inspection. If the property is part of a condominium, purchaser will be given access to the common areas to perform the inspection. Purchaser and seller shall have the right to be present during the inspection, and the purchaser shall give seller reasonable advance notice of the date and time of any inspection. If the purchaser or purchaser's agents or contractors damage the property during any inspection, purchaser shall be responsible for all costs incurred in correcting such damage. Purchaser's responsibility for all costs incurred in correcting any damage shall survive termination of contract. If either one of those are initial, they do not have to provide the home inspection.
Mine wasn't one of those. Thank you.
Well, I said you gotta wait. We'll get there. Calm down.
I know my business.
Number two, individual inspection contingency. And now keep in mind, this is the new contingency.
Mhm.
I don't think the old contingencies said that.
They do, actually, that sentence is on there. I have it pulled up. I have the old one. pulled
The
up.
old one, okay.
Yeah,
Individual inspection contingency. This contract is contingent upon the satisfaction of the inspection set forth below. The inspection contingencies until the expiration of time periods for such inspections set forth below from date of ratification deadline. If they didn't initial one or two, they're gonna initial that third one.
the new one is 7/22, isn't it?
And then, yeah,
Yeah, so no, she did use the new one.
so the next one says if the buyer fails to obtain an inspection, fails to deliver a copy of the inspection, deficiencies to the seller, fails to deliver inspection addendum or notice voiding contract prior to inspection deadline, the inspection contingency will expire and this contract will remain in full force and effect with no inspection contingency. Go ahead.
You know what she tried to do? So she called me the day before the inspection, right? And she said, oh, the buyer looked over some of the pictures and had one of her friends look over the pictures. And they said that there's water stain marks or rust stain marks on the basement floor. And she doesn't want to go through with the inspection. So we're just gonna have to go and do a termination and have the deposit released back. And I said, well, no, you're not. I said, because you didn't perform the inspection. And I said, so if you terminate today, I said, you don't get your deposit back.
She can terminate.
Well, she can, but it was solely based on the home inspection. So,
Well, if she doesn't, if it is within her time frame to perform the inspection, and they choose not to perform the inspection, and if as long as it's within those time frames, she can terminate.
well, their broker even said she couldn't get the deposit back. Because she had no precedence of termination. So the markings on the floor were clay dirt. They weren't rust.
Yeah.
So they did the inspection and that's whenever they didn't finish it and they said that, we just don't want to do this anymore, but they didn't send anything else over.
Now, if they initial number two and the initial number A, which number A says the property sold as is. Condition of the ratification date of residential sales contract, purchaser, and remember in the paragraph before, it said they had to provide the inspection report. The purchaser may have the property inspected by a West Virginia licensed inspector in the event the purchaser is dissatisfied with the results of the home inspection. The purchaser upon written notice to seller given within blank days from the date of ratification date shall have the unconditional right to terminate the contract. If the purchaser elects to terminate the contract shall become null and void, and deposits shall be dispersed in accordance with the deposit paragraph of the contract. If the purchaser fails to have the home inspection performed or fails to submit written notice of termination within the time period specified, purchaser shall have no right thereafter to terminate the contract, and the contract shall remain full force and effect. The seller shall make the property accessible for such inspection, blah, 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 goes into making it accessible. But keep in mind, number two, it specifically says this contract is contingent upon the satisfaction of the inspection set forth below, the inspection contingencies, until the expiration of the time period for such inspection set forth below from the date of ratification. The buyer fails to obtain an inspection, fails to deliver a copy of the inspection
Deficiencies to the seller.
deficiency
So
to the seller.
it could just be a list from the home inspector.
No. Fails to deliver inspection addendum or notice voiding the contract prior to the inspection deadline. The inspection contingency will expire. So they gotta provide the, if they initial number two, they have to provide home inspection report in order to terminate the agreement, along with the list of deficiencies. If they go to B, the home inspection, if they're saying they're doing a home inspection, it's not a right to terminate. Then the contract's contingent until 9 p.m. blank days after the date of ratification upon the inspection of the property by a licensed home inspector and or other West Virginia licensed inspector. At the purchaser's discretion and expense, the seller will have all utilities and services on inspection. Contingencies will terminate the deadline unless by the deadline, the purchaser has delivered to the seller a copy of the applicable section of the inspection report together with either a written addendum listing specific existing deficiencies. Seller may, at the seller's option, within blank days after delivery of the addendum, elect in writing to remedy the deficiencies prior to settlement. If the seller does not elect to make the repairs or makes a counter offer or fails to respond, the purchaser will have blank days after delivery of the seller's counter offer to accept the counter offer or accept the property in certain conditions or void the contract. Or a notice voiding the contract. Then the radon test, same thing, you've got so many days, you gotta provide the report. Mold inspection, you gotta provide the report. Private well and or private sewage, you gotta provide the report. It's also gonna be dependent on who's gonna pay for it. For the well and the septic, it's gonna be the purchaser, it's gonna be the seller. If the purchaser is gonna have the septic pump, or if the seller's gonna have a pump. Whatever the case may be. Wood destroying insects, if it is a VA now will allow a veteran to pay a termite.
Which they should have. Do you know how many conflict of interest there was on that? Because if you know somebody knows somebody knows somebody, they can say, just say that there wasn't anything there. I think that was always bullshit, and it's the cheapest fee. It's $45, come on. So if they didn't want to pay it, I did. I didn't like the seller picking who we used.
So keep that in mind, VA, they can pay for it.
Which is,
Sale of the purchaser's property and kick out. This contract is contingent on the sale of the purchaser's property located at. You're gonna put the address until 9 p.m. on the number of days at which time this contingency may be extended by mutual written consent of the parties satisfied by the purchaser per subparagraph A or B. So make sure you read A or B. Purchaser's property is to be listed exclusively for sale with. And then you're gonna put the agency from blank to blank, and is to be competitively priced according to fair market value. Who determines if it's competitively priced, fair market value?
The appraiser.
and I challenge that.
I know, but I mean, I'm just.
Okay.
Well,
It'd be a
I had
great,
one where the agent, when I told him that we were gonna have homicide contingency, he asked me for what price that I was gonna put. That she wanted, and I told him, he said, no way. He said, that's way over what that area is worth. I've had that happen.
and you may have that happen in West Virginia. They don't think it's gonna sell at that price. Not
He
because-
definitely told me this, there's no way.
Did
Because
you
I'm not
list
gonna-
it? Did you listen?
Mhm.
Did it solve that price?
No, I had to bring it down. I knew that too. I knew that too. She was just.
So then who set the price?
The seller did.
So the seller didn't know what the actual market value of the property.
No, she did. I shared
agree.
with her what what I really believed it would sell for.
Rosier's got one like that right now, and good Christ, we gave her all the comps and all the information, and you're like, look, you're like, you're just gonna look.
Oh, but my house is worth more.
So,
My house,
yeah, she's
Now-
like, well, they'll end up chipping me down anyway. Oh, gotta get them to come.
I love that too, because they can't see your house if it's in their price range and you have it up
Or
there.
the sellers that complain about showing.
I spent all this money on things.
Oh, yeah. See, I like going over that list with them. They're like, well, I put a new roof on it. And I'm like, well, can you take your roof off and not put it back? No. Well, I put a new HVAC system in it. Okay, well, can you rip out the heating supply and not put one back?
Did it need all
So if
that?
it's health and welfare, you can't sit there and say that it's gonna go.
Right.
That's health and welfare, and they hate that. Well, I did new carpet. Well, that's personal preference. The new people may not want carpet. So all the things that they think is gonna up the value, it doesn't. And you gotta
I
break
don't
them.
understand why it doesn't. Okay, just be in perspective, if I was a
Well-
buyer, if I saw that a brand new roof was put on and a brand new HVAC system, that would make me wanna buy it because I wouldn't have to worry about
They
it. for so long.
notate it, but it
So
doesn't like.
why
Really?
can't it
I-
up the value?
Because
What
it
is the
makes
reason?
it sell faster than the neighbor who doesn't have that.
Right.
Yeah, but it is.
I know of,
It is good.
I know of a home that has a brand new roof and leak.
Oh, yeah. New products are not always good, and that's what I tell my buyers.
I
They
know-
broke, don't
I,
fix it.
I know when my niece replaced her 3 air conditioning systems within 2 weeks,
They were broken.
that each
They
one
were
that was put in brand new.
Well, how about your fence?
So, you know,
You put up a new fence, Letty, and that thing, oh, what?
but I wouldn't mind, that was my son.
Oh.
No, but what brings up value
So-
in a home is when you've actually ripped out your whole kitchen and put a new kitchen. in. When you ripped out your whole
Yeah.
bathroom and put a new bathroom. in.
I know.
Right.
That's just
more
my
value.
value.
So here's,
I just don't
Yes.
understand.
Yeah.
here's the thing, when you're discussing price with a seller, believe it or not, the overpriced home is a violation of the code of ethics for the National Association of Realtors.
What, for the sellers, because they're not involved in that.
Sellers aren't involved in that, but you as an agent are. If you know that the house is overpriced and you take the listing, you can be in violation of the code of ethics.
But
I call BS on it.
yeah, I call BS on that too, because the seller sets the price, not
Yeah.
Tricia Larimore because of my comps. The seller, I have to convince them, this is the price you really need to put your house on the market for. What do you want to put it on for? Well, I want to put it on for $50,000 more, and I'm going,
See, I never asked,
okay.
I never asked them that question. I tell them what the cost.
Well, I do too, but I don't tell them.
And if
what
they want,
do.
if they want to go for higher than that, then I said, well, then you can certainly get an appraisal done.
Yeah, but
But
still,
appraisals, there's 2 different kinds of appraisals. And
There's
I don't
3
think-
different kinds of appraisals.
Okay, so I don't think that's fair to say that, because that's not true. You get someone in there that goes, well, I need another 20,000 for this, and the guy will, I've seen that.
I've never
happen.
seen
Stuff is just like-
standalone appraisals outside of a transaction be very fair.
And will they never match?
They don't,
They won't,
they
So,
don't.
and so it just.
because there's 3 types of appraisal. There's actually appraisal that you get done on your property because you want to know what the value is. That's going to be usually high. There's an appraisal that's done for a purchase, which is usually going to be low. There's appraisal that's done for an estate.
And there's also refi appraisal.
And, well, refi appraisals are basically whatever they want to get and what they're gonna add to it.
I mean, it's just like,
So there are differences in appraisals, but
and they're all, and what really bothers me about it's all a matter of someone's opinion.
it's all, yeah,
It has nothing, if it was really, it's a 3-bedroom, 2-bath, 1,800 square feet, and this one's 3-bedroom, 2-bath, 1,800 square feet, they have the same thing in it. This one can't be $10,000
course,
more than that.
this is the guy that doesn't have any listings right now because I won't listen if it's too long.
Well, I love whenever they come in and they're like $1,000 off and you're like, really, what was missing? A pair of Jimmy shoes? Like, you wanna be that on point, but you're gonna come down to $1,000, get the hell out of here.
Yeah, they do it.
It's very
So-
frustrating. It's very frustrating.
I did call out John Offerman one time. It took me about 5.5 hours to write that email. Cause I got up, I breathed a little bit, and sat back down. Got up.
I've contacted him a couple times. I got along with him pretty good.
Well, you know what's crazy is he acknowledged that he messed up very graciously. And although he didn't give me all my value back, he still gave me half.
He still
of mine.
gave you some.
He still get, which is unheard of with him, but he knew.
He's
He
done it for
knew.
me. He's giving me some.
Really?
Yeah.
Oh, very nice.
I've
Are you
won,
sure it's John?
I've been
It's
fortunate. I
John.
have won a couple that I've contested.
I don't mind contesting them.
No, I don't either, especially
Yeah.
if I find blatant error.
Yeah.
It sounds
A
more
lot of people,
recently.
well, I love David Coletta and times 1,000. He's very fair and he's on the appraisal management committee board. So if he's gonna cut your throat, he's doing it very fair. And I always know that. And he sent me one of
Talking about.
Coletta.
Here.
David
Oh.
Coletta, he's out of Alderman's office. But, he sent me a report like a couple weeks ago, and I pulled this thing up and I said, hey Coletta, I said, this is a whole different house. He had said, like, all the repair, I was like, we don't even have a garage. I said, what is this? And he was like, oh shit. And I said, Gina, you sent me a whole, I said, the address is right, and the photos are right. I said, but everything else is not right. And sure enough, he mixed two of them. And the lender was like, how did you, and I was like, what do you mean, how did I know? I was like, cause I've been to the property. Like, so it's the new list of repairs we got was a lot smaller. I was like, thank God. So they are not error free.
Kathy says the same thing that I said.
From Keller Mortgage.
The attorney,
Kathy Santa Barbara.
that,
She wants me to go ahead and send the contract over to her
okay,
because she doesn't understand what the other lender has to do, what the seller's lender has to do.
Right.
They got nothing to do.
right, and the fact they won't tell us what they're trying to do. this
Yeah.
for. Okay,
Okay, so the sale or purchase of property and kick out, this is where you're gonna put this in if the purchaser has a house to sell. And if you're gonna do that, be very careful. They are starting to be accepted.
$1,000 seller assistance. Okay,
And make sure that you have it listed in accordance to the timeframes that you put in here.
And once it goes pending, change it to a home to settle.
Correct. Sales settlement on purchaser's property, you're gonna initial that one if you initial the first one. You're also gonna initial coinciding settlements, because you want all the settlements to be coinciding. And if the seller's gonna be purchasing another property, contract is contingent until 9 p.m. blank date after the date of ratification upon the seller delivering a notice to the purchaser. Which I'm glad to see West Virginia has that in here. Maryland doesn't have that for some reason. So everybody always puts it on a general addendum and practice as well. If this is a backup contract, you should be putting it in here. And if it is a backup contract, the purchaser needs to be made aware that it is only a backup contract. They are not under contract. They can still continue to look for properties, and if they find a property, then they rescind their backup offer. Make sure it's rescinded in writing. Pre-qualification letter, if you submitted an offer without a pre-qualification letter, this allows them to do so, to get it through them within X amount of days. If there's a gift letter, they're gonna be using gift funds. Make sure that the seller's aware of that. Non-lender third-party approval, this is in the event there's a short sale or if there is a third-party approval needed. Which it sounds like in that land transaction, there might be,
yeah, which is never decided.
and it was never disclosed. Survey, if the survey is being performed, then that permission is granted, and who's going to, what type of survey? If it's a location survey, a perimeter survey, and if it's paid by the buyer or the seller. I always recommend that we mark that at least do a house location survey The buyer will pay for it. It's usually $200 closing. West Virginia, they have all the title companies over there, even Dave Bill will tell you. Well, you don't need to do that, have the title. You're right, you don't have to do a house location survey to have the title insurance. But if you're gonna have title insurance, you want the title insurance to be able to work, correct? So if you don't have a house location survey, the title insurance won't work. They're exempt from, if there's a claim that comes up, they don't have to pay that claim.
Oh.
So I always mark, if they're gonna do a location survey, the buyer's gonna pay for it. And then Dave will used to call me, are you sure you want them to do that? Yes, I do. Okay,
What's the difference between the two locations?
house location survey, they're just gonna determine that the house is located where it's supposed to be located, there's no encumbrances around it. And that's how I found in West Virginia, especially up in Berkeley Springs, that the house was built directly on the property line. So half of it was on the neighbor's property, the other half was on their property.
That's awesome.
And the guy that we were buying it from never had the house location survey done. So he did have title insurance, so he called the title insurance company to get it corrected. And the title insurance company said, well, you didn't have a house location survey done, I'm sorry, but that's not covered under our policy. He had to pay for it himself. Now, fortunately, the person he bought it from, he went back after him. And that happened to be, you know, Wayne Holmes is. So he is a Morgan County commissioner. It's also on the planning.
Oh,
He's also, yeah,
okay.
he's also on the planning and zoning and all this stuff. And he's also a developer and he owns a bunch of
They're
property.
big around there in Winchester.
Yeah. So he was able to correct all the problems himself
Oh,
because he did. He was the one that went up there and told the builder, build the house here.
There's one like that in St. Paul,
Yeah.
where it's like, it's over the one line, the guy was like, well, I knew it was over the line on this side, and he said, can we just like not say that? I'm like, no,
And then the foundation is collapsing, and he's like, well, it's gonna be a total flip, can we just say we fixed it? And I'm like, no, like,
No.
no.
Property restrictions, if the property, the purchaser has blank days to exercise a due diligence obligation with respect to information regarding, but not limited to, HOA documents and bylaws. Real estate licensed parties, the seller is or is not a licensed party. And in general, this contract is contingent to 9 PM blank days after the date of ratification on, then you put in whatever you want. Right? And then it's on. And last but not least, they changed the items to convey and the final walkthrough inspection. Yes, the final walkthrough inspection is required in the closing portion of your document. We want all walkthroughs to be signed by both parties. Sorry. I'm the bad guy on that one.
I just think it's just plus it came with me, everybody signs on there.
That's usually what I do.
I mean, well, Susie makes.
But
a copy
if
of
you'll
it.
take notice on the items to convey list, you no longer have to put yes or no, you only have to check if it's stayed.
good.
Now, because the other things are so confusing.
But yeah.
It's like, oh my gosh.
So,
I hate how they changed the PA one where it's only deficient if it's got a deficiency. Do you know how many people mess that up now?
yeah, everybody.
It just.
Pennsylvania's got a whole slew of changes.
Oh, I know. I know. That's why I just do the separate items in the sheet to make it 110% clear.
Pennsylvania's got a whole slew of changes. A whole bunch of different stuff.
Oh, trust me, I'm sure you'll make it to where, Dan.
Probably when it's too late.
After you get the phone calls.
Um, All right, so now they changed this, so you got the alarm system microwave. It used to say built-in microwave, now it just says microwave.
Mhm.
So if they have a countertop microwave, and you check microwave, does the microwave say?
Yeah.
It sure does. It says microwave. So if they have a countertop microwave, I would cross that out. If they're taking it with. Ceiling fan, clothes dryer, clothes washer, cooktop counter, dishwasher, disposal, freezer, garage opener with remote, heating stove. And what they're talking about, does anybody know what they're talking about as far as heating stove?
Wood burning insert,
Correct.
pellet stove.
They're talking about pellet stoves, wood stoves, things like that. I don't know why that was so confusing for everybody, but then there tells you, there tells you type.
Yes, it does.
Wood, pellet, whatever the case may, wood, pellet, propane, kerosene, whatever. Hot tub, playground, pool equipment, refrigerator without an ice maker, refrigerator with an ice maker. Storage shed, stove or range, wall mount brackets, wall oven, wall treatment system, window AC unit, window blinds, shades, and hardware window treatment installed. Now, the only question I raised about this was in the contract it states the wall mount brackets stay.
Mhm.
So that should always be marked yes, and how many. Now, if they're gonna take them and it's not marked yes, then they're gonna have to put that in under an item that does not convey. But if you read through, the next thing is the smart device. It tells you what device you're supposed to put in there. So if they have a Ring doorbell on the stage, that's what they're talking about, smart device. As is items, the seller will not warrant the condition or working order of the following items, so you list those. And then other items to convey.
3 cats, 2 dogs.
This one is a tricky one, items to convey, you need to be careful because the lender might not like that.
Correct.
So be very
So,
careful what you put there.
What you have to put, when you put the items
Not
to,
what furniture. Right. Not one.
No personal.
No added value.
well, then you would add in their items to convey all furnishings at no
Yeah, you
value.
you can put anything you want on there, like I said, you do that.
But then the last one is items not listed, do not convey. So,
What is that? I mean,
well, this isn't items to convey, so if it's checked yes, it convey.
right,
There's no place to put anything that's not staying. So if it doesn't, if it's not listed on this sheet, it does not convey.
well, I mean, that doesn't make any sense.
I'm not on the forms committee. I'm just telling you that they came up with. If it's not listed, so